Good afternoon, everyone, and welcome to another webinar in our series in construction adjudication. By way of introduction, if you have not encountered me before, my name is Samuel Okoronkwo. I specialize in construction and planning matters. I'm a specialist barrister dealing with those things at Mercantile Barristers. So we have this series of webinars practically to assist our clients who are engaged in construction and property and therefore the planning that goes with it. So if you are joining us for the first time in construction and property, and particularly in adjudications, we have a package of 6 webinars, 6-part webinars addressing issues in construction adjudication. So those 6 parts are part 1, preventing disputes and delays in construction projects. That is part 1 that we have already dealt with. We dealt with that in our previous webinar. If you did not have the opportunity of joining, feel free to log back on. I'm sure the live stream of it or the recording of it is still available for you to access either on YouTube or on LinkedIn. Part 2 is effective preparation for adjudication, and that is the subject matter of today's webinar. Now, parts 3, 4, 5, and 6, as you can see on the screen, are dealing with referrals and responses and dealing with what happens actually inside the decision of an adjudicator. What is it that adjudicators focus on? Part 5 addresses enforcing and resisting enforcement of adjudication decisions in the technology and construction courts. And part 6 addresses issues of costs, risks, settlement, and then we'll look at various case studies. So we make progress then today, as what we're dealing with is effective preparation. In essence, I don't intend to take you into, as it were, the nitty-gritty of the law, because of course, as I'm sure you'll appreciate, the facts and the evidence and the issues, as well as the law, are all case specific. So I'm not picking out one single case that we will address today. Is just getting your mindset right as to, I'm now going to embark upon an adjudication. What is it that I need to do? What methodology do I have to adopt? How do I begin to organize and prepare myself in order to aid my own ability to have a reasonable prospect of succeeding in my claim? Conversely, if you have just had an adjudication notice served on you, you will immediately need to get your brain into gear, as it were, and prepare yourself for defending yourself against the claim that is now at your front door. So why preparation decides outcomes? Adjudication is often decided before it starts, as I said in the slide. Why is that? Because more often than not, it is your preparation that assists you in winning. The common issues that we see with adjudications that we deal with. Now, you start off saying poorly framed claims. What is it that you're claiming for? Are you claiming unpaid valuations? Are you claiming for your extras and variations that you believe have not been properly valued? Are you seeking an extension of time? Are you bringing in delay and disruption? So how did it all arise? What is the claim that you're bringing? You have to clearly, in your mind, before you put pen to paper, decide what claim that you're going to pursue. Remember that in an adjudication is different from litigation, because in litigation, you can make multiple claims in your litigation. Professional judges are capable of dealing with your multiple claims. But in adjudication, it is preferable, it is in fact the requirement that you pursue a single issue. Therefore, don't jumble it all up, because one would even begin to attack the validity of your claim if you have jumbled up multiple issues in one, because you're only supposed to refer an issue at a time. Excuse me. So your poorly framed claims, try and avoid them. Frame your claims clearly so that pretty much it's an idiot's guide as to how to understand what it is you're seeking. Now, you then haven't framed your claim. You have to find evidence to support it. We encounter from time to time, in fact, more often than not, missing or inconsistent evidence. So if you have framed your claim, but you have not actually strung together the evidence to support the claim you're making, then your claims amount to no more than an assertion, and assertions are rarely successful. If you assert that this is what happened, the question will be, okay, prove it then that this is what happened. It is that material, it is that information, is that necessary piece of paper that supports the claim that you're driving that is essential. It's vital evidence, it's relevant evidence, it has to be there. So you try and avoid the issues of having your evidence either missing totally or being inconsistent. Now, if you're commencing an adjudication, you commence an adjudication by serving your notice of adjudication. If you serve your notices late, if you serve your referrals late, if you miss the deadlines, then you negate the adjudication. The other party, if they're wide awake, will take issues with that and can successfully destabilize the adjudication. Now, your submissions must not be disorganized. And clearly, adjudication is not fully appreciated. It's supposed to be, it is actually become a legal process. It's quasi-legal, but in fact, it's a legal process. And as such, you have to ensure that you're not disorganized in the submissions that you make. Now, consider also, if you're putting your adjudication referral together, whether you require an expert input. That expert, in other words, if you're a technical person, if you're a contract manager, if you're a project manager, if you're not fully au fait with how the numbers work, you probably require the assistance of a quantity surveyor. Or if you bring it all together and you're not sure that you have a coherent argument, then you probably will require the assistance of an expert lawyer, for example. So you have to look at that and decide early enough, and this is very important that you do so. So these are the common issues that we see. Excuse me. Now, today's objectives, therefore, by the end of this session, I would hope that you will have a clear understanding how to serve compliant notices. That although this is a matter that I bang on, if your notices are not compliant, your adjudication is dead in the water. An informed respondent will immediately attack it and will kill it. So how to serve a compliant notice, or how to serve your compliant notices, how to manage statutory deadlines. You have to remember that the adjudication is a statutory provision. Although most of the contracts, most of the standard contracts include it now, it is the prerequisite is a statutory provision. So there are statutory deadlines of the initial 28 days that can be extended by a further 14 days using the referring party's consent. Now, these deadlines are strict. They must not be missed, and therefore you have to be in a position to manage the statutory deadlines and ensure that you're compliant with it. How to build a clear and credible case. So you have to determine what it is that you're seeking, but then build a clear and credible case. If your case is not clear and not credible, it's unlikely that it will be successful. Now, what strong pleadings look like? I use the word pleadings. It's a technical legal phraseology for the drafting that you have to do for, say, your statement of case. They're typically your pleadings, and you have to draft them clearly and draft them very effectively. When to bring in expert evidence. Expert evidence is not so much in terms of the technicalities of it brought in largely within the rapid adjudication deadlines. However, if you believe that expert evidence will enable you make out the case that you're seeking, then commission that expert witness, of course, before the deadline, just in case the expert finds it difficult to meet the statutory deadline. So you identify the necessity for expert evidence early and then commission it so that you have it ready and then can deploy it at an appropriate time. Okay. You then have to, of course, work hard to avoid credibility loss. When the manner in which you run your adjudication, how you frame your argument, how you present it, the consistency of the argument that you run, and the steadfastness with which you advance it will give you credibility. But if you're chopping and changing whilst you're supposed to have had your case clearly outlined, then of course you're going to lose credibility. Credibility with the adjudicator is imperative, because the adjudicator, to all intents and purposes, the judge that you're looking at, his decision is binding pro tem, and you then have to comply with it before you seek to challenge it. So that is what I hope that at the end of today, you will be able to be clear in your mind that you tick these boxes before you start making your adjudication submissions. Now, pain points in real cases, okay? We routinely see where cases have been drafted and they're messy. So that's what I call messy pleadings. Messy pleadings. Remember that when you're putting together legal documents, you have to have a beginning, a middle, and an end. What is your storyline? Now, whatever it is that happened on site, you want to tell a story that is consistent in your pleadings, because your pleadings is your written advocacy. So imagine that you have to explain to me what it is that happened on site. Clearly, you have to set it out in a manner that it's easily digestible, that it is consistent, and it's also coherent. It's very important that you avoid missing pleadings. And once you've got your pleadings, your case theory, for want of a better expression, backed up with facts, now you then have to find your exhibits, which is what's supporting your evidential basis for making the case that you're making. So we see missing pleadings, then we see missing exhibits. So you have said that something happened on a particular day. So was there a request for instruction that was answered? If there was a request for instruction that was answered, you're going to claim that you made a request in January, but it was not answered until March or April, in which case several months delay has arrived, and then you suffered the difficulties. If that is the case, where is your request for instruction? You can't say that the architect gave me the information in February and therefore it was too late. Now, did you actually anticipate when you needed the information? And if so, did you seek it? And if you asked for that information, where is your request for that? Now, if you have that exhibit to say, look, I clearly asked for this in January, I didn't get the answer until April. Here is the exhibit that supports that. Your evidence is tying together. So now you've got your case. Now you have to make your claim and focus it specific and be direct and precise. And don't make fuzzy claims that are running from day one. Everything went wrong. On day two, it was still going wrong until we've come to the end of the contract and we're now 50 weeks behind. That is as maybe. If your claim is for an extension of time that you have requested, when was it that you requested the extension of time? When did it become clear to you that the original contract period was either going to be overrun or was being compromised? Did you serve appropriate notices to the architect or the contract administrator, whose responsibility it will then be to determine that matter? So don't try to combine your claim for saying, oh, I did variations of that I have just become aware cost me 50,000, but I did not particularize it at the time. Oh, at the same time, in doing the variation, there was also a 6, 7, 20-week extension of the contract time that I'm seeking because we were delayed in that process. That is true. That is as correct. That is as maybe. But what steps did you take at the relevant time to record the bits of information that you will require to present now? And that comes into what I describe as the late narrative changes. So if you've rushed in to make a particular case in your adjudication, and then when you see the responses, you then try to adapt your narrative, you will then find that it is unclear as to what it is that you're seeking. What's the correct narrative? Was it the first one you tried? Was it the second one or the third one that you're contemplating within the limited time scale? That will also contribute to your loss of credibility and the inconsistency that may then undermine the case that you bring. Now, if you're seeking a particular sum of money, have clearly calculated how that sum of money is arrived at. That is what I describe as poor quantum explanation. If you cannot explain the buildup of the amount that you're seeking, if it is approximating, then you're most unlikely to be assisting yourself in your adjudication. Your quantum calculation has to be clean, clear, precise as to how the figures have been arrived at. Are you using the rates that were used in the original bills of quantities at the square meter rate, the unit rate, or the cubic meter rate? Or do you believe that a different rate should apply? And if so, why? And at the very worst, are you seeking to apply day works for a particular set of claims? And if so, why would you argue that day works is preferable in the circumstances than the originally tendered rate? And if you are going to be claiming using day works, have you actually maintained a record of the day work spent? How many men, at what work phase, for what duration? Okay. Now, once you have put all of that together, remember that all of these pieces of paper will have to be put together in a disciplined, properly indexed manner in order that when you're running an argument, say in paragraph 10 of your, as it were, statement of case of your referral, that you're properly indexing the exhibit pages to which the adjudicator or the reader can refer, and there will be cross-referencing. If you're poorly indexed in your submissions, your document control is all over the show, therefore, the reader cannot follow you consistently, and the otherwise powerful case you have may be entirely lost due to poor presentation and poor indexing and poor document control and overall information management. These are all avoidable, and these are the things that you must seek to avoid if you're putting an adjudication together, or alternatively, if you're actually doing your responses to an adjudication referral that has hit your desk. Okay, notices and time limits. Now, valid notices are the foundation of jurisdiction. So if your notices are invalid, the responding party can specifically apply on the invalidity of your notices to knock out the adjudication, and parallel that with a further argument that if the adjudicator fails to stand down, then they reserve their position with respect to the jurisdiction of that adjudicator. Because ultimately, if it was found against them, they would turn around and say, well, this was an invalid adjudication because the notice invalidated it ab initio, and as such, we made that point, and the adjudicator didn't take it, and it would be unenforceable. And in fact, if the notices are defective, the courts will refuse to enforce the adjudicator's decision, and you probably would have run the course and incurred all the expenses for no just outcome. So the key points here is that you must serve your notices correctly and on time. Now, you have to also deploy what I call clear crystallization wording. So recall that an adjudication can only commence when a dispute has crystallized. And what does one mean by that? That breaking it down quite simply, simplification is this. If I am seeking something and I have presented it to you, and I am, as it were here, the person seeking it, and you have responded rejecting my request, and I have made attempts to try and reach an accommodation with you, and we are still at cross purposes, then there is a dispute. And that dispute crystallizes when we've reached a point where we can't, as it were, as between ourselves, negotiate it away. And then either contracting party will be entitled at that time to seek the assistance or to serve a notice of adjudication to seek the assistance of an adjudicator in accordance with the contracts in order to try and resolve that. And where the contract fails to make a provision, of course, the scheme for construction contracts will kick in. So clear crystallization wording of the dispute is necessary before you proceed with your adjudication. Check the service clauses that are in your contract. Please ensure that you comply with it. Now, if you have drafted a clear notice and on time, but you have served it incorrectly, you may well find that that invalidates your adjudication notice. I've known a case where adjudication notice was served on site. Question: was it served at the registered address of the contracting company? Answer: no. Adjudication fails. You have to start again. Now, you track statutory and contractual periods. Therefore, contract provides the durations and windows within which certain steps may be taken. And the statute makes provision. Of course, you start with your contract, but in default of your contract, the statutory time period kicks in. You have to track it and stay with it. You should also endeavor to avoid waiver by conduct. In other words, you are supposed to do something. It hasn't happened. Or the other party was supposed to do something, more to the point. It hasn't happened, but you have not taken the steps that you're supposed to take. You have, by implication, quite unwittingly affirmed that failure to comply, and you have waived your position by way of your conduct. Endeavor to avoid that. Okay, so building your referral structure. Your referral must have a clear and factual narrative. An adjudication is a fact-sensitive. Every adjudication is fact-sensitive in order to try and determine what happened. So what are the facts? What actually happened? Forget everything else that you want to claim. What's the chapter and verse of what happened? Make sure you capture that. And that is very important, and put that narrative down. Now, things may have happened factually. It doesn't necessarily entitle you to a payment, or it doesn't necessarily prevent you from having to pay for it if you were the employer. There is, of course, a legal basis, there's a contractual basis, and where there are no appropriate contractual terms or contractual clauses that cover it, there may well be good legal basis for it. Establish what those legal bases are. So you have a clear factual narrative, you have clear legal basis for your claim, then be clear in your mind what relief you are seeking. The relief you seek is how much are you asking the adjudicator to award you, and for what? So the adjudicator needs to be told, I am seeking £250,000 for the variations that are particularized in my statement of case and is backed up by the evidence. That is the relief I need you to grant. Or alternatively, you're saying, I seek the relief that the contract, you are now at the final account stage, you have not dealt with your extension of time. You're now finding that you're potentially exposed to a 10 weeks delay and 10 weeks liquidated and ascertained damage, or damage is claimed. But you are submitting your adjudication referral, and what you seek is an extension of time. Have clearly mapped out how long do you think, or how long do you know that you want the adjudicator to award you, and for what reasons? And set out, if you like, the critical path of your construction program. Identify the areas where you say the delays have occurred and why those delays occurred, and why those are relevant items to be taken into consideration in trying to extend the contract time. So your relief sought must be very clear, so that the adjudicator reading can say, okay, the claimant says A, or the referring party says A, B, C, D equals I'm entitled to. Here are the factual basis why I'm entitled to it. Here are the legal basis why I'm entitled to it. And this is what it is that I'm entitled to. That much is clear. So your quantum, how much you're seeking, is cleared. And then you have the documentary evidence, as I have pointed out before, properly indexed to go with it. And there is a logical flow. So when one reads your referral, there is a logical flow from start to finish, and it's backed up. And it's almost, I would say, impeccable if it's properly done. Okay, now quantum and relief sought. Why clarity matters. Now, ambiguity in what you're seeking weakens your claim. You may turn around and say, the adjudicator, I need you to determine how much I'm entitled to. You're giving the adjudicator the job to do. Now, what is more effective is to say, this is what I have calculated that I'm entitled to, or some other amount which the adjudicator will be at liberty to determine. So you're telling the adjudicator quite clearly what it is that you're seeking, but also at the same time giving the adjudicator the capacity to calculate otherwise if the adjudicator works out that by his own calculation on the basis of the evidence you've presented, that the different figure is more applicable. So any ambiguity in what you're seeking will weaken your credibility. Look, adjudicators are not mathematicians. They need simple arithmetic. If you can work it out, work it out. Don't give them the job to do. If you give them the job to do, you are likely handing over your fate entirely to their calculation. Best and better, I say, to give them figures that you have calculated, but then give them the liberty, as it were, if they have done a different calculation, to show how that has happened and how that differs from what you have calculated and you're seeking. Now, it's also important to break sub-issues down. So I was dealing with a case where the amount being claimed was in multiple underpayment of interim payment certificates. So interim payment certificate 4 was underpaid by 15,000. Interim payment certificate number 5 was underpaid by 50,000. Interim payment certificate number 6 was underpaid by, say, another 40,000. Now, depending on how you have framed your notice, if you were seeking to claim for underpayment for a particular certificate, that would be the limitation of what you can claim under that adjudication. But if you have framed your notice such that what you seek is underpayment of interim certificates, then you can aggregate those. But then you will have to be able to break down under one main issue, the sub-issues down, so that they are logically flowing to coming to the end of the main issue that you're seeking. In fact, in the case that I have in mind, that I was talking about, an argument arose as to whether those sub-issues are amounted to different issues, which will therefore invalidate the adjudication. But we successfully argued that they weren't different issues, they were sub-issues within the same main issue, and that was accepted, and that eventually brought home the answer that our client was seeking. So you reference supporting documents clearly, and again, I've seen submissions where the same set of documents have been included 7 times over without any reference to it. And you're looking at it, what story is it supposed to tell? Every single document that you put in your adjudication bundle must be telling a story or must be linking as part of a chain of documents that tell a story. If you have that mindset, then think about it before you chuck it in. Don't just, as it were, data dump. Make sure that every single piece of paper is relevant. And also remembering that you're paying for the adjudicator's time. The more superfluous document you put in, the more the adjudicator will have to consider, the more the adjudicator will have to charge for his time for reading entirely irrelevant material. Okay? Your strong cases, I say generally, you can see the quantum presented in minutes. Once you are reading the referral document, you can get to the quantum rapidly. Okay, now, what's your evidence strategy when you're presenting your referral or your response, as the case may be? Good evidence must be relevant. It must go to the issues that you're looking to prove. They must be verified or verifiable. Verified in the sense that you should be able to demonstrate in your side of the argument that this information was in the possession of the responding party. So I gave this notice on that date. I have it. I sent that email, and this is evidence that they received that email. Okay, I transmitted that document. They have it. So it is relevant to the issue. It is verified that is on both sides and is properly indexed and is linked to the issue that I'm trying to prove. So I'm trying to prove a particular variation. I'm able to say that I have drawing number 6 revision A, which did not give sufficient information, and I raised a request for information on drawing number 6 revision A on that particular date. Revision B was not issued to me until that date, and I have the drawing issue sheet to show it. So there is a relevance to the issue of the variations that I say are encapsulated in revision B of the drawing. I have scheduled it out, I've quantified the variations. You can see the difference between this drawing and that drawing, and here is the variation. Here is my calculation of it, and on that date I submitted it. But for some inexplicable reason, either the architect, the contracts administrator, or the PQS appears not to have acknowledged it, or if they did acknowledge it, they have failed to give me credit or pay me for it as I did. And this is, of course, from the contractor's point of view. And of course, you also have a position from the architect's position to show that, look, there was a request for this information, which I received on a particular date. Within 7 or 14 days, I issued all the necessary information and instructions required. I cannot see why that could have caused a delay. Just as good an argument in response. And I have my own data, my own documentation, which is consistent. And how could you say that that is what has caused you delay? It obviously didn't. And if it did cause you delay, why didn't you realize it at the time? Why didn't you give appropriate notices? Okay, you have to avoid, as what I have indicated earlier, volume dump information. More often than not, you get all of the information that your client has retained in their folder electronically, they've dumped it. Now, if you do volume dump, the risk to you, as I say, whoever you're volume dumping on, be your professional advisors, be the adjudicator, they're going to spend time to sift through the information. That will be at your expense. And when they sift through that information, they are left second guessing what information is relevant to what issue that you're trying to make out. It is incumbent upon you as the proponent of the case to take time, as it were, to identify relevant evidential material, the documents that prove the case. So you have to take the time. If you can't take the time, then have a professional advisor on your side who will do so. It is dangerous to volume dump on an adjudicator. It's highly inadvisable because it doesn't assist your case. It delays everything and costs you more money. Now, seen more repeatedly than not is unexplained screenshots. Screenshots have been taken off your laptop. You are attaching the screenshots. They purport to be evidence, but they tell no story. They go to no issue. What is it that this screenshot is supposed to show? And I see multiple screenshots of WhatsApp messages passing between parties to major contracts. So what story is it telling? What is it going to? Now, we have had screenshots that have led to very successful pleadings, in the sense that the screenshots are showing that, look, here is my calculation of what I sent you on that date. You have not responded to it, or you have ignored the following issues, and why is that? And that is evidence in support of the crystallization of the dispute in the run-up to serving your notices. Now, emails. The way they're printed and deployed as evidence, because you've got reels and reels of evidence. Just consider that each email should actually take a sheet rather than printing multiple emails on one sheet. Because if you print multiple emails on one sheet, sometimes the earliest is at the top, sometimes the latest is at the top, depending on the manner of the printing. Now, if they are printed and just chucked in, one heck of a confusion to try and follow. Please try and discipline it. Now, your adjudicators mightily respect clarity. If you get jumbled information that is higgledy-piggledy presented to your adjudicator, it doesn't assist your case in any way, shape, or form. So your evidence strategy should be clear. It should be relevant evidence only, relevant material only, material that is verified. Okay, it is. The other side is not going to say, we've never seen this document before, because you're going to say they're there. You're going to have them clearly linked to the issues that you're arguing, and you're going to so index them that pretty much as the adjudicator is reading your submission, they can follow through. And the responding party can do the same as well. So exhibits and indexing, and this is an administrative exercise, but incredibly very important. There is nothing worse than trying to present a case and finding that your documents are all over. Now, getting your exhibits properly indexed with exhibit numbers, nothing could be more helpful to you. Every single exhibit will have a descriptor. What is it? The source from where it has come should not be in doubt. And if you are in describing the evidence that you're relying on, you can quote the page range in your index bundle where the documents can be found, and they are linked to the issues. I think it sounds as though one is over-egging the pudding, but nothing could be more helpful to you than that administrative element of ensuring that the case you present is well organized, the indexes are clear, and it massively increases the credibility of your case, because it can be, he who is prepared, of course, is very well organized. And if you see someone who is disorganized when they are in an adjudication, you can then wonder how much preparation they've made. Now, if they haven't prepared, is this a case that they all of a sudden realize that they're losing a lot of money and therefore they need to bring an adjudication retrospectively in an attempt to claim their losses? Or is it that there are actually genuine points at issue which the adjudicator will need to address and deal with? Clearly, you want to be in the latter category than the former. So if you're the respondent, I call it the respondent triage. For respondents, now, your early triage of the referral that you've received is imperative. Now, when you're reading through the document, ask yourself, what is it that is being alleged that can be accepted? What is factual? Do not argue, do not reject, do not precipitate a debate on something that is self-evidently acceptable. Because if you begin to argue, it is one more question for the adjudicator to answer. And if the facts are weighted against you, it can only be found against you. So once you are reading it, going through it, what can be accepted? What must be challenged? What is it that's being asserted by the other side that they can't prove? And particularly where their evidence is disjointed or not going to the issues. Do you have a counter narrative? If so, what is the counter narrative? What is the strongest counter narrative that you can advance? And if you're advancing a counter narrative, do you have the evidence which the other side have failed to adduce? And if you do have that evidence, deploy it rapidly, saying, look, the narrative given with respect to how the delay to the project arose is incorrect. What happened was that the contractor himself was short of either material or men at an appropriate time. And on that day, where they programmed to do A, B, C, they couldn't advance it because they have limited number of personnel, or that the materials that they were expecting did not arrive. There was a delay from the supplier. Now, if that is the case, and you have that, and you have the evidence, and that's the counter narrative, advance it, put your evidence, and you simply answer a point as to why the contract was delayed. Because, of course, the cause of the delay will then fall back onto the other side rather than on your side. Now, if you have taken, or in fact, having received the referral and in fact having received the initial notice, consider whether there are jurisdictional issues to take. What do I mean by jurisdictional issues? If you think that there is anything remotely wrong with the adjudication or the adjudicator being on seat, have no difficulty in challenging the adjudicator's entitlement, one, to accept the referral, and two, to decide on the issues that have been put before them. Now, if you have come to the conclusion that there are jurisdictional points, take them. Invite the adjudicator without hesitation to abandon the adjudication. Remember, of course, that every adjudicator has the entitlement to determine their own jurisdiction. Once you've raised that point, they will take time to consider what you have said, and they'll come to the conclusion as to whether they are going to accept your proposition that their appointment is invalid in any way, shape, or form, or even if their appointment was valid, that the matters that have been advanced for them to decide is one that they couldn't for another reason. Now, if they come to the conclusion that they ought not to be proceeding with the adjudication, then of course they will resign and they will stand down, and that will be the end of that adjudication. However, be prepared also that the adjudicator may consider all of that and then come to the conclusion that they are able to proceed with the adjudication. If they are able to proceed with the adjudication and they say so, you must then retort with your acceptance or otherwise of the adjudicator's decision on their jurisdiction. The adjudicator may decide on his jurisdiction, that is, his entitlement to be on seat and proceed, but that decision is non-binding. Therefore, if you are the party who is challenging the jurisdiction and you receive a non-binding decision that the adjudicator has decided to proceed, you must then make it clear whether you want to withdraw from the process at that point, which invariably is inadvisable in most cases, or otherwise that you are going to participate, albeit on the protest. You're saying, look, I'm going to participate. I'm protesting that you shouldn't be doing what you're doing. Should this go against me, I then have the opportunity to attack before the court the issue of your jurisdiction that I have raised. That gives you an opportunity to be able to take that jurisdictional point at an enforcement level before the court. And if you have taken an initial jurisdictional point, reserved your position, proceeded on the protest, the court will hear your point, your jurisdictional challenge, and decide whether the decision made by the adjudicator is one that the court are content to enforce, or alternatively decline to enforce. However, if there are valid jurisdictional issues and you fail to take them, or indeed you take them too late in the process, the court may well come to the conclusion that, be that as it may, adjudication was always intended to be rough and ready. You had the opportunity to take your jurisdictional point as early as possible. You failed to do so. You've made your bed. You must lie on it. You proceed, and you must abide by the adjudicator's decision. So ever so important to consider whether there is a jurisdictional point to take, and then to take those points at the earliest possible opportunity. You would note that I'm raising and, as it were, emphasizing the issue of jurisdictional challenges on the part of the respondent during a respondent who's received a referral. Clearly, the referring party is most unlikely to have any issues with the jurisdiction of the adjudicator that he himself has caused to be appointed. The responding party more likely to have that point, and therefore should consider that and then exercise that opportunity. I cannot overemphasize that taking a jurisdictional point must be at the earliest possible opportunity, not at the latest possible opportunity, because the later, of course, the worse that it will be for you. And when you've received the referral, consider also whether you require expert support in trying to address it. And if you do, get on your bike, as the case is, and move at it rapidly to get yourself whatever expert support that you require, particularly if the referral notice comes embodying an expert report of which you had no prior knowledge notice. You then may well want to equip yourself accordingly to be able to respond to it. Now, expert evidence, you use them, maybe sometimes in valuation issues, albeit that the parties may have contractual rates that they may be deploying, or if you have delay issues, or there are other technical matters. Again, timing of it, you can't be doing it too late. I say you can't be doing it too early, but let's face it, really, if you require expert evidence, the earlier the better, not the later the better. Clearly, adjudications were designed to be handled entirely by technical people, i.e. people, professionals in the construction industry. But I'm finding, and most other practitioners are finding, that counsel is being involved very early in most disputes. Definitely those disputes with a degree of significance in terms of value and their import as well, their emphasis. The reason being that it is practically litigation stepped down. And if you lose it at the adjudication level, you will have to abide by the adjudicator's decision. Now, would you rather have the adjudicator make a decision that you should pay 1.5 million, which you must obey before you begin to challenge? Now, having paid out 1.5 million, what's the point in trying to fight a rearguard action, particularly in certain cases where the receiving party may well bank money and become insolvent? And I find that counsel is being involved early to assist with addressing those claims. Counsel will ordinarily help you with refining your pleadings and making sure that is, of course, of the highest possible quality. Counsel is already an expert in theorizing the facts that you have produced in order to articulate a clear narrative that takes practically you from the starting to the end of where you want to get to. And the evidence, counsel, of course, will be there to assist you to map the evidence that is required to prove what issues in the case. So you have your facts, the narrative from which the issues in the case are deduced, then the evidence that is required to support it all, and the drafting of all of that, because I've already said that your drafting is advocacy in writing, drafting your notices, drafting your referrals. And if you do require experts and you're going to brief experts, who better to brief your experts as to what the points in issue that have arisen in the case that the experts should focus their attention. More often than not, you find that early involvement of counsel can shift the outcomes early for you in your favor, only if the cost is, of course, if the value of what is at stake is sufficiently high and the risks to the business of winning or losing, then, of course, the higher the value of support you bring, the better for you. So you must avoid common pitfalls. Avoid unfocused submissions. I have hinted at this at the outset. Vague quantum calculation and presentation must be avoided at all costs. You want to avoid missing of exhibits. You should always avoid late new arguments. Articulate your arguments at the outset, make sure they are clear, and then go at it. Your narrative must always be consistent, not inconsistent, and avoid poor structure in putting your case together. I'm conscious that time is running, so I'm going to go a bit more rapidly. So your practical workflow. So you want to check issues of jurisdiction, confirm jurisdiction, serve your notices correctly, map the narrative, identify the issues in your case, build an evidence pack. Now prepare your quantum schedule, the respondent, if you're receiving the claim, then you have to triage it. See where you need experts, instruct them, draft your responses, identify, as I've said before, what can easily be acknowledged and accepted, then identify what has to be challenged with your own counter narrative, the strongest counter narrative with the evidence that you have. At the end of it, quality check your documentation on every occasion before you submit it, whether it's your referral or your responses. Okay, what your strong case looks like, what your strong pleadings look like. Okay, it's coherent, it's in its narrative, it's precise in the issues that it's identified, it's clear on the legal basis that one seeks to justify a claim or to repel one. The quantum calculation is simple. That is to say, it is easily understood. The evidence trail is clear, and the professional presentation, of course, helps you narrow in. And that is what your pleading should look like in putting your referral together in the course of an adjudication or your responses. Now, in later webinars, I'll deal with case studies. Now, key takeaways today. So you strengthen your case by serving valid notices, controlling your deadlines, building a clear narrative, presenting your quantum precisely, organizing your documentation, deploying experts wisely when required. So we hit question and answers. And this is me going at it rapidly. Now, as I deal with the questions that you may wish to raise, I think I need to point out that I've been reminded in one or two webinars subsequently by people who've written in subsequently to say, look, I have questions, but I didn't want to ask them in the open course of the webinar. If that is your position, that you have issues that you wish to raise, questions you like to ask, but you would rather not ask them in this forum, have no difficulty in scanning the QR code and told us on the screen. That will lead you to either my LinkedIn, or indeed you should be able to email my chambers, or indeed book a quick call with me to raise those issues, ask those questions, and see how I can help you. Right. Okay. Questions before me. First one is, all these parts 1 to 6, going to be separate webinars. Do we have any other construction planning topics planned? First and foremost, we had an awful time getting planning. Okay, I have another series of webinars addressing issues with planning. So the parts 1 to 6 of the construction adjudication webinars are 6 separate webinars. You can watch them individually, or you can follow the series from start to finish. There are specific planning ones. What we're in here is the course of the adjudication webinars. Okay, these are adjudications, a separate series of webinars running in the new year for planning. So by all means, keep the contact and you'll be able to log on to those. But if you have specific adjudication questions, as I said, scan the QR code. If you had awful time getting planning, perhaps that's something you might wish to learn from or get assistance on. Again, have no difficulty in making contact, and to the extent that we're able to, we will be able to give you the support and help you require. Okay, the second question I have is, do you need a lawyer to draft your submissions? Can't a competent site manager, planning consultant handle this for me? There is no compulsion for you to deploy the services of a lawyer in compiling your adjudication. But imagine for 1 second that your opponent has instructed a barrister. Ask yourself, do you want to go to, as it were, a gunfight with a knife? Because they'll shoot you at a mile. By all means, deploy the services of a competent site manager or planning consultant to present one. But if they're faced with fact management, evidence handling, and legal argument, and deploying precedent and authorities and legal concepts, will they be as equipped as your lawyer? Probably not. but then it is for you to judge the value of the dispute to your organization and, as it were, what is most cost effective for you. It's not, quite frankly, if they are very small value claims, probably you wouldn't want to use a sledgehammer to crack a nut, by want of a, if you like, a better explanation. But if it is of any significant value, just imagine that your opponent has gone to the trouble of hiring a professional lawyer to deal with the claim, and you haven't. They may just be able to have a better argument than you do, and that may be the difference between success or failure in your case. Okay, that was the question. The next one is, are there money limits on what can go to adjudication? We have a relatively small dispute on finishings, £7,000, and a big dispute on steel for £400,000. There is no upper or lower limit. Provided it's a dispute in a construction contract, it could be put before an adjudicator. And in fact, I believe the RICS have what they call a small value adjudication process that is a bit more fast track. So that is an answer. You cannot be limited just because it's 7,000. You should be able to bring an adjudication and advance it. What happens to costs if you decide to settle? Can you settle if you started? Of course. If you have started a claim in adjudication, parties can always compromise their dispute. And in fact, it is highly advisable. If you've commenced a dispute and outside of that dispute, you and your, if you like, contractor and employer are having dialogue, although good lawyers will discourage that because you may say something outside of the process of your adjudication, which could potentially compromise the adjudication. But if you have started and you believe that you reached a point that you can agree a settlement, you can agree a settlement and present a consented decision to the adjudicator, which I'm sure the adjudicator will accept and seal for you. Now, that is one way of bringing it to an end, or both parties can come to an end and say the adjudication is at an end, agree the adjudicator's fee and settle it, and tell the adjudicator that they need not produce a decision. I would have thought that an adjudicator who's been asked not to produce a decision would also put it in writing that they have been requested not to produce a decision by the parties, and the parties will have to sign it and then release the adjudicator from their obligation. Because once an adjudicator is appointed, they're obliged to produce their decision, not just produce their decision, but to produce it within the statutory deadline. So if an adjudication has started, you can settle, and please have no hesitation in settling. Settling preserves relationships, and guess what? It saves costs, saves what you pay your lawyers, saves what the adjudicator will end up saving. Now, another question, is the adjudicator always a lawyer then? I thought it was a fellow working construction professional. Am I wrong? No, you're not at all wrong. The adjudicator can be a profession. The adjudicator is often a construction professional, but you will find certain construction professionals with legal training and ability. So, for example, I started my own career as a quantity surveyor, and then I became a project manager before I became a barrister. So if I'm having to deal with an adjudication, not only do I have the practical view of actually having built things, I have the consultant's view of having managed things from a consultant's perspective, and I have a view from a legal perspective of having actually argued these cases and understanding the legal concept. No, the adjudicator does not have to be a lawyer. Certain cases require, when making the application for the appointment of an adjudicator, to add that an adjudicator with legal knowledge will be beneficial in resolving the disputes, because the legal issues that are engaged require, if you like, greater knowledge in order to be able to deal with it. But there is no requirement at all for the adjudicator to be legally trained. No necessity for that. It's incumbent upon the parties to flesh out the legal issues that arise in the case and hope that the adjudicator will grasp those legal issues. Should the adjudicator misconstrue the law in arriving at their decision, particularly where their jurisdiction has been challenged, it may well give an opening. It's not a definite. It may well give an opening to challenging the enforcement of their decision. And that is the key point there. So the adjudicator does not have to be a lawyer. Now, I'm conscious that we're racing on time. Now, are there any more questions for me to address rather rapidly? We are just marginally over the hour slot that we have booked for this webinar. So if there are any last questions, I'll pick those up. But if there are questions that arise after the webinar, have freedom, as I say, to contact my chambers, scan the QR code, make the link, and then ask your questions. So the next webinar that we'll be dealing with will be part 3 in the 6-part series. You'll be dealing with how to present your referrals and how to present your responses, okay? The issues that you have to consider and engage. Okay, now if there are no further questions, I will bring our webinar to a close today, and thank you for your involvement and participation, and look forward to seeing you in the next one. Now, if there are, as I said before, any matters that you wish to address further, please have no difficulty in scanning the QR code, making contact, joining on LinkedIn, or otherwise emailing my clerks in chambers, and I'll be able to pay attention to any issues you have. And thank you very much for attending. Look forward to seeing you next time. Bye-bye now.